Hello, good afternoon to you. Many thanks for joining us. You're watching Democracy and the Rule of Law coming to you this Sunday from Ghana television. The presidency did not enter into any deal with the embattled Justice Walter Onnoghen before he decided to resign his appointment as the Chief Justice of Nigeria, as Sunday Punch is reporting. Onnoghen, who is undergoing trial before the Code of Conduct Tribunal for failing to declare his assets, resigned his appointment on Thursday. There are speculations that he resigned after reaching a deal with the presidency through the intervention of Vice President Yemi Osinbajo. But the presidency official who spoke to the Punch on condition of an meeting on Saturday said there was no such deal. He also insisted that there was no deal with Onnoghen, with or without Osinbajo. The source said it was clear to all from the beginning that the allegations leveled against the former CJN were weighty. He said Onnoghen apparently waited for the verdict of the National Judicial Council on the petitions against him before he took the decision to quit. Welcome once again. My name is Justin Academy. We're looking at the resignation of the former Chief Justice of Nigeria, Walter Onnoghen, and vis-a-vis the NJC's recommendation, which was supposed to be submitted to the presidency. Lots of reactions are beginning to trade a particular development if the CCT trial will continue or just what will happen in the coming days. We have our legal practitioners with us here in the studios, and we'll be talking about it in the first half of the show. Plus, we will also focus on the alleged certificate forgery of Adeleke is still in the news, and just yesterday there was a verdict by the appeal court. Just yesterday, we're looking at the implications of all of those on the show this afternoon. But before we get into the discourse proper, let us take this quick soundbite from the last day of the CC trial before all of this happened, when Justice Onnoghen and his team closed their case. Be right back, still with us. Welcome back, and it's still Democracy and the Rule of Law. We will bring you details of that report as we go on the show this afternoon. Joining us this afternoon to look at all of these issues are three legal practitioners. To my immediate right, let's make welcome Barrister Stanley Emmanuel. Many thanks for joining us on Democracy and the Rule of Law.
Thank you.
Also joining us this afternoon is Barrister Ajibola Kaka. He is also a legal practitioner. Thanks for joining us here today.
Good afternoon.
And of course, we also have Barrister Kunle Oshibogu. Many thanks for joining us, gentlemen, as we look at all of these issues that have taken over most of the dailies and, of course, discuss across lawyers in Nigeria. Let's talk about this resignation proper. Let me start with you, Stanley. When you first heard about the purported resignation of the CGN, Walter Onnoghen, how did it meet you?
Well, when I heard of the resignation, I tried to confirm the reality, and I was hoping that it's true. Thankfully, it was true.
You were hoping that it was true?
Yes.
Why were you
because
hoping it was true?
that's the best in this situation. Some of us expected the CGN to just throw in the towel in view of the allegations levied against him. But other persons were of the view that they are mere allegations. But some of us were particular about the status of that of it, because it was beyond just the CGN. We're talking about the judiciary, because as the CGN, he embodies the entire judiciary of the country. And dragging him before the Code of Conduct Tribunal for the world to see was not something ordinarily palatable. So it could have been avoided one way or the other.
Okay, Barrister Kaka, he's talking about the fact that it is a welcome development, but the school of thought would say that why now? A school of thought would actually question the timing, because there have been calls for him to have resigned a long time ago, but this is coming just a day after there was supposed to be a report by the National Judicial Council, although the NJC did not really give out details of the report. But there are a lot of insinuations and reports online and, of course, across various media that they were actually calling for his retirement, as it is. In your opinion, would you say that the timing is actually a good one?
Well, the timing, I join others in saying that it's not a good one. It came rather too late. At least it shouldn't have waited that long, even for the NJC's decision to come out before it now decided to throw in the towel, right? It's rather too late.
Okay.
And in a way, one may say that it's even preemptive in nature.
How so?
Because the NJC decision was communicated directly to the president, not even made public in any way. But somehow, I believe that it's privileged to have that kind of information, and he now quickly threw in the towel by resigning, because he knew what the decision of the NJC would be, going through the overwhelming evidence before the NJC, and what the EFCC counsel, what they presented before the NJC, and there's none of those allegations that he can actually deny. And as a result, he now looked at it that, well, the best thing for him to do is to throw in the towel. Though
but the NJC did not
is,
really talk about it, because they said it is actually will be sub judice if they went on to comment about all of those allegations.
Well, none of us actually have seen what the decision of the NJC is actually about. Well, we may say it's speculations or this and that, but at least substantially, it has been recommended for compulsory retirement.
Okay.
And if that be the case, now throwing it to her by putting his resignation letter, or as his counsel, the lead counsel, Chief Awomolo, said, that it's not a resignation letter, but notice of retirement to the president. Whichever way it is, right, is another issue entirely, because the presidency will now be content with either accepting the resignation or the retirement, or pushing him to the National Assembly to recommend him for dismissal or for that compulsory retirement as, propounded by the NJC.
Okay, let me bring you into this conversation, Barrister Oshibogu. The presidency's aide over the weekend still said they've not actually received his resignation. So right now there are talks about whether the presidency or the president should actually accept his resignation or not. No, but if he actually resigns, in judicial terms, what are the implications? And let's talk about maybe entitlement, looking at all that has happened so far.
Thank you very much. I'll start by saying that I agree with my learned friends on the left. It's a little late, but I'll also say there's a difference between his resignation and his standing by. As at the time he received that petition, I think the first thing he should have done was to stand down from that position. And I think that culture is absent in our political system, in Nigerian culture totally. If you are being indicted in an office, most times there's a sit down, sit tight mentality that until I fall, I'm not going to move. But then you put that whole office into ridicule. And that's what the members of the bar had to experience for a period of time, having their CGN been in the dock. But now that he has resigned, or he's submitted his letter of resignation, I think that goes a long way to say that, well, he's no longer going to be the CGN. But how does that impact on his retirement benefits? I think maybe that's what he's trying to say, but that doesn't affect the CCB process that's going on. That tribunal is going to deliver its verdict, and whatever
if he decides to resign.
Yes.
Okay.
It would have to see it through, because the allegations are still there.
Okay.
It has to. It would not. His resignation would not end that. Save for if if he's entered a negotiation with the presidency that I'll resign and please take this off take me off this case. But then it puts to question the whole administration of justice, because I think in a situation where a man that high has fallen short, or it has allegedly fallen short of certain constitutional provisions, I think it won't be ideal to just sweep it under the carpet. So I would say it wouldn't affect the CCT verdict. That will still go on, should go on, so we can actually get a resolution to it as to did he actually run foul, yes or no.
Okay. So how would you react to that specifically, as in judicial terms? What are the implications would be?
First and foremost, please, I think we need to do some background. At the point of his arraignment, the issue of jurisdiction cropped up. Okay. Some of us have opined elsewhere that approach was ordinarily not proper. The proper thing to do was to have dispatched a petition to the NJC and let NJC investigate and make the necessary recommendation. Of course, for tactical reason, and maybe to just escalate it, the executive took that step by filing a charge at the CCT. That was that position. And of course, the CGN and his team felt there was need to challenge the constitutionality of that procedure. Yeah. The executive took hint from the public actor, particularly from the legal community, that look, the first step should be the NJC, EFCC, pronto lodge a petition, the AGF lodge a petition. What we have seen today as recommendation from the NJC is a function of those petitions against the CJN then to the NJC. The NJC set up a 5-member panel and they reached a conclusion. They've recommended to the president, although we are not privy to the details. What we have so far, they are just snippets of the content. We want to believe that they are correct. And the NJC recommended compulsory retirement.
Yes.
As you hinted, perhaps the CJN got the hint and quickly put in his resignation letter or notice of retirement. Whichever one it is, the CJN has bowed out. That is the implication. And that is the safest way in the circumstance. On the issue of whether that trial should continue at the CCT, some of us are of the opinion that at this stage, you will remember that under Section 23 of the Code of Conduct of Tribunal Act, one of the punishment is vacation of the office. By resigning or giving notice of retirement, the CJN has already taken that off from the CCT. The next sanction could be saying that in the next 10 years, he should not occupy any public office. And of course, for future of whatever he has acquired. Technically, one is almost tempted to say that the AGS should enter a nolle prosequi at this stage. Bear in mind that under that same section 23 of the Act, that someone is sanctioned under that Act does not mean that the person cannot be tried by EFCC or other agency of government. So who would suggest? Because at the end of the day, the Court of Appeal is still there. The decision of the Court of Appeal in Gajiwa against AGF, and of course the Supreme Court decision in Alelu Habib against the AGF decided in 2012 is still very extant, and that is the foundation upon which any disciplinary action taken against a judge should be anchored. This procedure at the CCT offends those principles as leader in those cases.
Okay, Barrister Kaka, let's just look at it. Let's just tweak it a bit, and maybe even try to be a bit preemptive. What if the president were to, refuse the resignation or does not accept the resignation of CJN Onnoghen, and NJC's report actually asks that he should retire? What really happens next?
Well, what if the president rejected his resignation? The next thing to happen is for the, according to the Constitution, is for the president to push the NJC recommendation and place it before the Senate. So the Senate now will sit on it, and if, the provision of the law is that they must meet 2/3 majority before the CJN can be removed. Where the fear there now is that the present Senate has constituted, having in mind even the head of the Senate, they may not want to, do the bidding of the president or be able to meet with that 2/3 majority. And as a result, that is another problem for the executive to be able to carry out the recommendation of the NJC. And however, where they decided to, in a way, accept the resignation, the question that the people are asking is that because the benefit that will accrue to the CJN, the hard-earned money of the citizen, which means we go home with the full benefits, which runs into billions of naira. And that will be laying a bad precedent. If somebody committed a crime and is supposed to be punished, is not punished, and we are now patting him at the back and saying, okay, go home with all the largesse, then we are encouraging others to do the same, which is a bad precedent. But now, the two, whichever way it takes, is another problem, because we have acting CJN presently, and his tenure as acting CJN will soon expire, right? Then are we going to have a vacuum? So the president just has to take a decision, either by accepting the resignation or putting placing something before the National Assembly, and then in another way, which means they will have, because there's no way, if it's before the National Assembly and it has not been confirmed or recommended as recommended by this NJC, which means they will have to appoint maybe another acting CJN, because there can never be a vacuum. Okay. So that is the problem that the president will be faced with. Okay,
Barrister Oshidogo, let me get your thoughts concerning that as well.
Yes, I'd just like to write on what Barrister Kaka said and also respond to Barrister Stanley as well. What I would say is that to the extent that the CJN has submitted to the jurisdiction of the CCT as we speak, and proceedings have commenced, right? Until the AGF enters a nolle prosequi, that proceeding will go on, and whatever decision comes from there will be binding on the CJN. What you then find out is, having resigned, if he's ordered to vacate office, what will be the impact of that on his retirement benefits? So what we have here, and which is why I align with Barrister Kaka here, is that the issue is his benefits. So right now he's no longer in that office, but should he be entitled to go home with all his benefits? If the presidency accepts that resignation, automatically he will go home with those benefits. But that will be another pat on the back. So, but to the extent that the CCT finds him, assuming finds him guilty of those allegations, should he be then allowed to go home with those benefits? I think that's the moral question that we will have to ask, and we'll then see what decision the president takes on that, because the president will then be faced with those two scenarios.
Okay. One of our first time before take a break.
Yes, thank you very much. You raised a very vital importance here. In the procedure of disciplining a sitting judicial officer, what is the role of the president and even the Senate, as it were, a judicial officer of that caliber, CJN, by virtue of paragraph 21, A and B, part 11 to the set of the thus due to the Constitution. The NGC will recommend the removal of the CJN to the president for action. Now, the CJN, the NGC in its wisdom has recommended that he be removed by way of compulsory retirement. Does the president have the discretion to decide whether to accept that recommendation by the NGC that has the constitutional power to discipline a sitting judicial officer? The NGC has made that recommendation. Can the president vary it for any reason to say dismissal? Or can the president write the National Assembly, intimating the National Assembly of this position in line with section 292 of the Constitution, stating that instead of compulsory retirement as recommended by the NJC, it should be dismissal to serve as deterrent to other judicial officers? I think that's the dilemma there, because generally you will say the president and the Senate do not have a role to play in that disciplinary procedure. They are merely to act pursuant to the recommendation of the NGC. That for me is a point we may need to look at maybe in future.
Okay, we'll still talk more. We'll still take more reactions concerning the implication of CBN Onnoghen's resignation. But we want you to join us in this particular conversation via SMS. If you have contributions or questions for the panel, feel free to do so. The number is now on the screen, and we will take your thoughts and your questions. But let's take those snippets from the last CCT proceeding of last week. We'll be right back. Stay with us.
After very careful review and consideration of the evidence that has been laid before this honorable tribunal, and then comparing it with the provisions of the law and the Constitution, we came to the conclusion that we should close our case at this point, that no case whatsoever has been disclosed, as we said in our no case submission, and then having the benefit of calling a witness who has established what we think is relevant for our defense, we think it's sufficient for the case.
It was like when I called 3 witnesses and I closed the case and offered them to the others. In their court, they didn't even offer me the witness they subpoenaed. But I'm not surprised. They are the judges of their own case. So they decide when to close or not to close and so on. But what I'm happy about is that neither the prosecution nor the defense has delayed this matter. We behave as real officers of the tribunal.
Welcome back. If you've just joined us, you're watching Democracy and the Rule of Law. You just watched snippets from both parties about the issue at the CCT. The CJN's team had to close, their proceedings earlier than normal. They were supposed to present about 3 witnesses, but they eventually ended up just doing just 1. If you were to review the proceedings and of course all that has come out of it, what would you really say as per all of that, and what are the moral lessons to draw from all of that? I'll start with you, Barrister Oshibogo.
Well, moral lessons from the proceedings. I'll say counsel is entitled to call as many witnesses as he wants. There's no obligation for him to call all the witnesses he's listed, provided the other counsels are entitled to cross-examine if they deem it fit. So it's clear that the prosecutors believe that they've established a case based on the sole witness they called. So there is very little. I think if you say moral, I think one of the things I would say is it's important for us who look at people in those offices with high esteem to look at what has become of you not paying attention to little details. That's the moral lesson I'll take from it. That no matter how minute a little thing is, a document that you need to file, I think it's important that we take this thing seriously. Because looking at his history, based on the petition that was submitted, I think since 2005, that's when this issue has started, where he hadn't filed regular forms. So I think for that period, it's important for us to look at it as individuals that it's pertinent to pay attention. The higher we go, right, the more responsibility is on us because there are more people behind us looking up to us. And I think that's the morals I'll take from that story. But I would also want to add on to that, because in this situation, there are three things there are three prongs. The first is resignation, which if the presidency accepts, then he gets his entitlement. The second is the NJC, who recommended that he be retired, right, which then goes through the Senate. The third is the decision of the CTT or CCT. Because if they then declare that he vacate that office, automatically that's a decision of a court, which is binding, set aside by a superior court. Now, if that's the decision that comes out of this whole episode, would he be entitled to his entitlements? I don't think so. That's why the issue of plea bargaining, and if that has actually happened at all in this scenario, also comes into play. Because I think there are also assertions that there have been negotiations done for him to be eased out. We don't have any facts on that, so we can't really speak to that issue. But if that's the case, taking into consideration his office, nobody wants to ridicule. It's ridiculing the entire justice system. So if that's what the executive has done in its wisdom to look for a soft landing, like we call it, I think that's fine. But it's important that that be established as well, so that people who are coming behind use that as a reference point, and we take these little things seriously. That would be my submission.
Well, the moral lesson is that, it is often said that what is worth doing at all is worth doing well. So people should not be negligent in whatever position they find themselves. If the law requires us to do certain things, we should carry it out to the latter without any dereliction of duty and making total disclosure of what we're supposed to disclose to the public. And I think that is what the CJN has actually done in this instance. And by even agreeing and then a kind of admission or admitting that he actually forgot to disclose all those things, right? With that, those who are crying that there is no case against him or this and that, that is sufficient enough as a prima facie case that has actually been established against him. And as such, well, it's a lesson for all of us that we have to be up and doing in whatever we are doing or what we are asked to do by not leaving any stone untouched. Now, on the other issue, as Barrister Oshibogun posited, that the issue of maybe plea bargaining or whatever, I think at this stage, after everything has been blown open, to do otherwise, right, may be a kind of disservice to the nation and even to the judiciary itself. Disservice in the sense that we are saying that, well, I don't want to use the word maybe that we caught a thief and we now said, okay, he has already surrendered all that he has taken as serious. So why are we prosecuting him again? That it will look as if we are persecuting him. But it goes beyond that. At least I believe the law should take its course. Then if it's going to be given a soft landing, yes, but not that it should not serve as a deterrent to others. Let it be known that when so thing happen, these are the steps taken, and that is the reference point that he's talking about. So the presidents actually need to be very careful in the decision that they have to reach in the long run. It's very important.
Barrister Stanley, what are your thoughts?
Yes, for me, when you look at the CGN, and of course the office in particular, you would have expected that the occupant of that office would have resigned when the issue of arraignment came on board, rightly or wrongly, just because of that office. But different interests literally bought over that case. When I say bought over here, I mean they just felt this is our battle. So that was, I want to conclude, I stand to be corrected, that there was so much pressure on the CGN not to back out. That this is like a case, a tribal case, you know, all manners of interest. And the CGN, you know, yielded to that pressure. I'm sure, before he took decision, he did not consult all this special interest. That was why I was able to take that decision. Many of them were even taken aback. So the moral lesson for me is we should be careful why we allow other people propagate our interest. Because the interest that took over this matter made it political matter between APC and PDP. And today the CGN is almost the victim of this whole interest. So if the CGN had bowed out, in spite of all the pressure to remain, you know, people will say, look at the case of Saraki. He went through the entire hall and he came out clean. So that was pressure on the CGN. But thankfully, it has not been needful.
Okay. In all of this right now, what becomes of the, okay, I've asked that before, the NJC's recommendation, but looking at the office of the acting CGN, what becomes of it right now? Will Justice Tanko Mohammed be made substantive on CGN?
Well, they cannot make him substantive CGN if Onnoghen's matter has not been dispensed with. As it is, the resignation is yet to be accepted, or the retirement. And if you are going to face the recommendation of the NGC, right, it has to still be laid before the Senate. That has not been done. So there's no way they can confirm Tanko as the substantive CGN. What they, at best, even they cannot even say that, okay, they want to reappoint him in acting capacity. There's no law that says that. At best, what they can do is to have him as well set aside, right? Let him step aside, then another acting CGN is appointed. Or otherwise, let the resignation of the current one be accepted. If that is done, then there is way, they've cleared way for him, then they can be appointed as substantive CGN and sworn in accordingly.
Okay, Barrister Shudo, your thoughts?
Well, I think Barrister Kakas has nailed it. He would only be appointed an acting or substantive once the issue of Onnoghen gets settled. Once he's still suspended and not either retired or dismissed, then automatically the position can't be substantive until that issue is resolved.
Okay, you want to add to that, Barrister Imaro?
Yeah, in that same, from what we've heard from the grapevine, in the CGN NJC recommendation, they recommended compulsory retirement for Honorable Justice Onnoghen, and of course, equally recommended that Tanko be made the substantive CGN. So once the pending issue of whether the action to be taken on Onnoghen's case is done with, perhaps we could proceed to confirm Tanko, and that will be it.
All right, we're still expecting your comments and your thoughts concerning the discourse for today. Some are already coming in. Let's just read one or two of them. You didn't say what your name is or where you're calling from, but let me just read your anonymous comment. In Nigeria, people in high places fumble and get soft landing, but it's the other way for the lowly placed. A judge involved in an act unbecoming is getting an option of retirement instead of outright punishment. The same judge Okay, don't call, just send an SMS. This same judge might have actually sent many to jail on the same account. He ended by saying life is an irony. This is from Ahmed from Abulegba here in Lagos. This episode is the okay, it's funny putting the cart before the horse. If such are the priests, God bless the congregation. I'm trying to understand what you meant by that. Good afternoon. Who are we deceiving? Please, can you tell me the difference between a man who did not declare all his assets and the man who sits at the affairs of a nation without a result? Okay, this one says what is important is that Walter Onnoghen has been okay, try and righteous, but I really could not really make sense of what you were saying. This is Davis from Dolphin Estate in Lagos. Concerning the case of the CJ, and I think we should just face the reality that the man is he has not been sentenced or anything. You're saying guilty of illegally enriching himself. He should be prosecuted. Full stop. All right, keep the messages coming. We would take them as we progress, but we will take a break. When we return, let me just give a bit of a background of what we will be discussing next. The Accra Division of the Court of Appeal Saturday affirmed the qualification and eligibility of the Osun State governorship candidate of the People's Democratic Party, the PDP, Senator Ademola Adeleke, to seek election as governor. Presided over by Justice M.A. Danjuma, the court dismissed the appeal against the judgment of an Osun State High Court sitting in Osogbo, which had confirmed the eligibility of Adeleke to contest for the governorship of Osun State. The court had Justices R.A. Abdullahi and P.A. Mahmoud as members of the panel. But the People's Democratic Party, in reacting to the judgment, said it has castrated the judgment of the High Court Abuja because it had nothing to stand on. The Osogbo High Court had ruled that Adeleke was qualified to contest for the governorship, having been educated up to the secondary school level. Not satisfied with the High Court's decision, the runner-up in the governorship primary election, Dr. Akin Ogumbi, proceeded to the appellate court to challenge it. The appeal court agreed with Adeleke and consequently dismissed the appeal on 3 grounds. We'll come back, we'll look at those grounds that the court judged its findings on. But we'll take snippets from the proceedings from last week and come talk some more. Stay with us.
Came up the last adjourned date. After we took 2 witnesses, the court adjourned it to yesterday and today. So we couldn't go on yesterday because I was at the Court of Appeal. So we are here today. We took 2 witnesses in continuation of the case of the prosecution. So after taking the 2 witnesses, the case has been further adjourned for continuation of hearing.
Of the trial of the criminal case today, the prosecution called 2 additional witnesses in support of their cases, and we were all allowed as defense counsel for the purpose of cross-examining them. We cross-examined the court witnesses, and the matter was further adjourned at the instance of the prosecution because, according to the prosecutor, he is having a matter in the Supreme Court in respect of a criminal matter, as a result of which he will not be able to make himself available for continuation of trial.
While we are set to appeal the judgment, we also find it compelling to put the record straight by listing out the fatal flaws in the ruling and why it cannot stand before any court. It will be recalled, first of all, that the matter in question has been addressed by 2 high courts ruling, affirming that in the face of the Constitution, Senator Ademola Adeleke is qualified to run for the governorship office. The 2 rulings delivered in September 2018 held that Senator Adeleke satisfied all requirements of the law to contest for office. It is trite in law that once a court of coordinate jurisdiction has ruled on a matter, court of similar jurisdiction cannot entertain it.
What we're trying to say is that the judgment is actually a victory for the people of this state. I say this because since the creation of the state some 28 years ago, we have had, even in the old Oyo, we've had leaders who have really been at the aim of affairs in the state generally, who are very well versed in their profession, in their trainings. So how come we have to go for the very lowest of less educated person?
All right, welcome back. It is still Galaxy today. Just before we get into that deeply, one more comment on the Onnoghen issue. It's soft landing to save our judiciary. Okay, well, some writing here. Okay, in Ghana, Jerry Rawlings killed corrupt judges, but you press. Okay, you know, journalists, right? Also, the problem. Think of Singapore, military dictatorship. Who became, okay, I'm trying to process your thoughts together, but they're not really well coordinated. So write us back and we'll try and read your comment. All right, before the break, we're talking about Adeleke and his alleged certificate forgery saga. Okay, the appeal court agreed that Adeleke and consequently dismissed the appeal on 3 grounds. It held that the trial court had no jurisdiction to entertain the suit and that the sponsored petitioner, one Kingsley Awoshion from Ife Central, had no local standard to file the case. The court also held that the matter was brought to court outside the stipulated 14 days after the conduct of the primary election. The Osun State Governorship Election Tribunal had, in a split judgment, declared Adeleke a winner of the governorship election. Gentlemen, you've heard the proceedings from the appeal court. I just want to get your reactions concerning all that happened. Let me start with you, Barrister Stanley.
Yes, thank you very much. We're talking about the qualification of Senator Adeleke to contest for the position of the governor of Osun State. Section 177 of the Constitution provides for the qualifications, and in that particular section talks about minimum requirement of school certificate. Yes. What then is school certificate? To understand the import of school certificate, we must have recourse to the interpretation of the Constitution, and that is section 318 of the Constitution. School certificate was defined in about 4 sub-paragraphs there. Secondary school leaving certificate, primary 6 leaving certificate, and 10 years service in public or private sector in any institution acceptable to INEC, or attendance of courses in some institutions to a minimum of a year and acceptable to INEC, or other conditions as qualification acceptable to INEC. The question here is, if you fill your form that you have secondary school, you have primary 6 leaving certificate, and that you have worked in some sectors, whether private or public, for a minimum period of 10 years, you are qualified. So it is wrong to even say you must have a secondary school certificate before you can contest for that position. For all our positions, elected positions, primary school leaving certificate holder and one who has garnered some experience in public or private sector acceptable to INEC is even qualified. Now, for the issue of Adeleke, Senator Adeleke, with due respect, he claimed that he went to social school and he acquired the secondary school leaving certificate. There are cases on this, 2 in Osun State and 1 in Buhari High Court. The Court of Appeal decision that was handed out yesterday did not go into the merit of whether it was qualified. It was purely on technical issue. The one that came in on Wednesday or so, the one of Buhari High Court, went into the merit of the case as to whether there was alteration, forgery, and all that. And the information is just coming back and forth. INEC is saying, yes, this is the position he participated. NECO, I understand participated in NECO. NECO just came up by about 2010. NECO said, well, we didn't see him in the exam hall. So on this matter, we get to the Supreme Court. What I'm trying to say in effect is, whether Adeleke is qualified or not is a function of the form and the particulars he gave to INEC. If he claimed to have had secondary school leaving certificate, of course, people are free to print to it. And if there are manipulations, the court will take the appropriate decision. And I think that was what the court in Buhari, Abuja, High Court in Abuja, looked into. They went into the merit of the case. White and NECO will eventually have the final influence of what becomes of that particular case.
Barrister Kaka.
Well, while aligning myself with my learned friend on the issue, well, the Constitution has stated, Section 177, that the school cert is the minimum requirement to contest in an election. There are other authorities, that is, cases that say that even S75, that is, by not completing the school cert, what is important is that, okay, yes, you are, but you know, when you graduated in Form 4, you will have your testimonial that you attended that secondary school, right? So as a result, that once the Constitution says that is the minimum requirement, is qualified, and the appeal court is right in that respect. And the other issue, whether there was certificate forgery or whatever, or they did not see me in the exam or whatever, well, is that one cannot be a matter to be commented upon now, because I believe and we all know that the criminal aspect of that is still in court, and the law will surely take its course. If they find him wanting that yes, he forged the certificates, well, it's another different ball game entirely. But as it is now, yes, he has presented a school certificate result. Whether it is F9 parallel or he has distinction or whatever, it's a non-issue. So what is important is that yes, it's qualified and he has the minimum requirement. And that is it.
Okay, Barrister Kunle, what do you have to say concerning this exactly?
Yes, well, I would say that the Senator Adeleke issue has brought up quite a number of things from our Constitution. And I'm appreciative of my learned friends for referring to Section 177, which says if you want to run for that office, for the executive office, you must have been educated up to. I think that's where the issue begins. If you're educated up to, do you have to have passed, or do you just have to attend? I know some of the decisions referred to by Barrister Stanley actually just said, look, mere attendance is sufficient. To the extent that there's evidence that he's attended, it's fine. But then, looking at the decision from the FCT High Court, that then said, no, you must have passed. There has to be a certificate. And that's when the issue of fraudulent or forged certificate now comes in. And I think it'll be quite unfortunate if a Senator of the Federal Republic of Nigeria has submitted a forged certificate, because that then goes back to the same issues that we discussed earlier on. And I think that would be a criminal case, as Barrister Kaka said. But it's important for us to now look at it from a holistic perspective, being that if a potential governor of a state, the debate is if he has a school certificate, that's the issue. I think then we need to have a rethink, because I doubt if the spirit of the Constitution, when the drafters were drafting it, was for the barest minimum to be achieved. I think that is what is giving a lot of people, especially in that state, a little worry. That look, we have graduates, we have PhD holders, you can't even scale the minimum level of a school certificate. And it's quite unfortunate. It is very, very unfortunate. But riding on that, what then happens if he's, because I also know there's a Court of Appeal decision, or there's the tribunal decision, electoral tribunal decision, that's upheld the victory of his party, the PDP. Now, where that becomes interesting is that if the court nullifies Senator Adeleke's primary election, participation in primary elections, does that necessarily mean the APC then takes that ticket? But we all know that the courts have also settled that it's the party that wins. Okay. So that means there's another gentleman who I'm sure came second in that primary election that is really putting a lot of fuel into this fire that, look, we need to resolve that issue. So I wait to see how it will play out, because it's going to lay a lot of precedents, because I would worry if the courts hold that mere attendance of secondary school is sufficient to become, a governor. I think that's where, and I think the issue of constitutional reforms now comes back into play. That look, sections like this, we need to clarify them, make sure that they're clear enough, and increase the bar. We need to increase the bar for public office holders. I think that's what I would comment. I'll comment on this.
We'll talk to the other lawyers to get other precedents that should come out from this. But let me take one or two comments as we begin to round off. APC should accept defeat and allow Adeleke to rule. Have we seen the certificate of the president of Nigeria? This one says the president should also resign in the interest of justice because he has failed the integrity test by not tabling his certificate to INEC up till now. God bless Nigeria. I like what the man from his state said, that they don't need low standard people. We saw the way he was dancing. Gentlemen, now let's just round off now. Barrister Kaka and Barrister Stanley, let's talk about precedents that should come out of all of this. Kunle Oshibagu has given us his own perspective. Let me get your own perspective as we round off.
Well, he said something about constitutional reforms.
Yes.
You recall that when those days, understanding one of our presidents was just a great true teacher. I think Shagari, if I'm not mistaken. The drafter of the Constitution had in view general participation of all citizens in the electoral process. And you agree with me that certificate is not actually synonymous with wisdom. We've heard stories of people like Bill Gates and some other dropouts who went to develop their skills, and they became superstars and role models in the society. We've seen graduates also who occupy positions of authority and they just looted the system. So, give and take, the qualification for me may not be the issue. That section that talks about minimum requirement. If we are to raise the bar to say maybe first degree, many persons won't be qualified to contest the election. At times, leadership is equally inborn. We've had a situation where a particular governor in one of the states didn't even have a certificate, but he acquired some experience from courses here and there, and he did very well as a governor. So it's a challenge. If there is need to review that particular provision, the bar should not be set too high, so that we can allow for general participation in the process.
Final word, Barrister Kaka.
Well, I'm in support that the Constitution should be reviewed and let the bar be raised. At least maybe OND, NCE level, because even many on the field as politicians, we know the problem that these people, they are really posing because of their low level of education. Nigeria at this stage, we really need to move forward. We don't need dons, we don't need those that are less educated. When we have so many professors, engineers, lawyers, so many graduates, then why should it be those that are school sat fail that will be determining our fate?
Okay.
We really need to do something about it urgently and let the Constitution be reviewed.
And something we must do, and the Constitution reviewed. I will just drop the anchor on that this afternoon. We've been looking at the resignation of CGN Water Onnoghen, and of course on the Senator Adeleke's alleged certificate forgery. We had Barrister Kunle Oshilogo joining us this afternoon. Many thanks for being a part of the show. Also, thank you to Barrister Jibola Kaka and Barrister Stanley Imarwan. Many thanks to both of you.
Thank you very much.
Yeah. And to all of you who have contributed in no small measure, we do appreciate it. Let's keep the comments flowing. Democracy and the rule of law will return again Sunday by 1 p.m. Bye for now. I am Justin Akadoni.